In case you have not, it is through that side door. The ladies' restroom is to the right of here. The men's restroom, I have never figured out, even though I've been with this firm for 13 years. So you'll have to, and I'm starting your PowerPoint. That's awesome. Wow. Okay. Wow, and I'm going the wrong direction? I don't know what I'm doing. Somebody needs to fix that. So, men's restroom, I don't know. Seth, do you know where it is? Charles?
Yes, just go through the lobby and through the door on the opposite side of the reception, and then it's right there.
There you go. So now the men know where to go, and I've learned where the men need to go. That's fantastic. So thanks, everybody, for coming. We should have people from O'Melveny here. Yes, raise your hand. O'Melveny person. Jacqueline, since I know you, I'm going to tell you personally to get a binder for O'Melveny. And we have a step-toe person. No step-toe people. Step-toe is in big trouble. Okay. One coming. Okay. A Winston and Strawn person, perhaps? Also in big trouble. Excellent. Proskauer? Yay. Wow, Proskauer all together. I like the camaraderie. Come fetch 2 binders for yourselves. And Munger Tolls. The one Munger Tolls guy. Hey, good job, Munger Tolls guy. Come get a binder. Any other mystery firm that is not Manat sitting here? Manat, you don't get to get binders. I get all the binders, and you can come find them from me. So that's pretty much housekeeping and logistics, and I'm going to turn the show over to Amos Hartston, who is got some big fancy title at Inner City Law Center and used to be the me at Latham, so he understands both the law firm world and the do-gooder world, so he's a great brain to pick if you have any issues whatsoever, and he will lead us to wisdom, Amos.
Thank you, Kristen.
And CLE stuff.
All right, so thank you to Kristen and thank you to Manat for hosting today. Very excited to be here for this training. Some of you have already had a brief introduction internally at your firm or with some of the materials we sent out. I'm going to give you a very brief overview of the program, and then tonight's really a training about eviction defense law and unlawful detainers. But first, a very high-level overview of the Shriver program, because it is really exciting. And it's unusual because it's a collaboration between 4 different legal services organizations in Los Angeles. That's Neighborhood Legal Services, Legal Aid, Public Counsel, and Inner City Law Center. My name is Amos Hartston with Inner City Law Center. And what we've done here is this is under the Sergeant Shriver Civil Counsel Act, previously known as AB 590, but now it's actually in the government code, and it's a pilot project. There's 7 different pilot programs around the state of California. We're one of them, and it's a pilot program for civil legal services. And really, the idea is to provide low-income Californians with critical services affecting basic human needs. In Los Angeles, we're focusing on housing. Housing is a basic human need, and for low-income Californians, there really is a crisis of affordable housing, a crisis of decent, livable housing. And what we have here, because of all different reasons, people are being evicted, and they don't have counsel. So this is really a fairness, an access to justice program where we're trying to give low-income Californians that are dealing with housing matters, eviction cases, fair access to the justice system so we can level the playing field. The idea of the Sergeant Shriver Civil Counsel Act is as a pilot program. So this is a test program to test for civil legal services, to show that having an attorney and providing access in this way to these critical legal issues that are civil cases rather than criminal cases makes a difference, and it makes sense to do. So it's also an evaluation program. This program is something that there's going to be an evaluation. We're going to do data collection. We're going to be a volume business. We're going to be representing a lot of clients, both with staff attorneys at each of the organizations as well as through pro bono resources. And we've had firms signed up as founding legal firms, so founding partner firms. So we really appreciate the interest of you personally and of your firm to really get on the ground floor of this exciting project. A little bit more about housing and why housing is, I think, a perfect fit for this test program as an evaluation for providing legal services in civil matters. So we know that in criminal matters where life and liberty is at stake, there's a rule that you're entitled to defense being provided to you if you can't afford counsel. There's no such right in civil cases. So all over, in all types of civil matters, people who can't afford counsel are going unrepresented. But sometimes one side is represented and one side is not, and it really is an imbalance. And what we see in housing is what happens is oftentimes in unlawful detainer and eviction cases, one side is represented and one side is not. Thousands of cases are filed. And for legal aid doesn't have the capacity. These statistics are somewhat dated, but just in the Stanley Moss Courthouse, which is a downtown Los Angeles courthouse, over 18,000 UD cases, unlawful detainer eviction cases were filed in the 2008-2009 year. And you know, I don't have current statistics, but it's about this. We believe it's about the same. It's a staggering number. That's just one courthouse. That's not the whole county for 1 year. For people who can't afford representation, legal aid is usually the only option. And legal aid does not have the capacity. Legal aid in the form of one of our organizations or similar free or low-cost legal services. And there's just no capacity to help even close to that number of people. So even if they qualify for legal aid, they're oftentimes going unrepresented. This program is a test to see if it makes a difference to have an attorney. We know that it does. We are trying to prove that and help as many people as we can. So the program really does two important things. Helps a lot of people, and through the evaluation shows whether or not we're making a difference. And I think it's going to be watched nationally, really, as a pilot program for the funding of legal services and access to justice and the need to address the issue in critical legal issues on the civil side. The key statistic here, though, really is that fewer than the 1% of unrepresented tenants win their cases. There is a difference. Having a lawyer makes a difference in these cases, and the large majority of cases go unrepresented. Now, our program is low-income Californians where one side is represented and the other side is not. So our program is actually open to tenants or landlords if they qualify, although for the most part it is tenants that we represent, and we expect that'll be the large majority of cases. So just a little bit more in the overview. What we're hoping to do, what you're going to get tonight, is an overview of the eviction defense process and a training for what to expect and the laws and defenses in an unlawful detainer eviction case. We're going to go over it specifically. In Los Angeles, we have a rent control statute, so you'll hear about that, and you'll hear some of the defenses. A lot of them are technical defenses because an eviction case is a summary proceeding. It's not the normal civil case. It's on a much more rapid schedule, and you'll hear about that schedule. But because of that, it's a very technical court. The notices, what you put in terms of amounts, the defenses, and it has to be exactly right for it to be an appropriate case. So you'll hear about all those issues. But really what we're trying to address is getting fair access to all litigants and getting good settlements. And just so you know, I mean, the other thing to think about is if there's an eviction judgment in a case, that affects the ability. A lot of these tenants, because they're low income, they don't have the ability to go find alternate housing, so they could end up homeless. So it's also a homelessness prevention program. Also, some of these units, sometimes they're being evicted so that the rent can be increased. It's a affordable housing unit because of rent control, but once the tenant is evicted, whether it's legitimate or not, it's an attempt to flip the property into a higher rent or market rent unit. And so even for we see a lot of long-term, low-income tenants. You might have somebody living in this unit for 10 years, 20 years, and they're being evicted not through any fault of their own, but because there's some attempt to circumvent the rent control statute and raise rents, because the way the rent control statute works in LA is if you legitimately evict a tenant or have a vacancy, you can raise rents to the market rate. So there's oftentimes an attempt to create a pretextual reason to evict, and it could really cause low-income tenants and families to become homeless and not have an alternative. Even in cases where the tenant wants to move or needs to move, providing an attorney really can make a difference, because you can avoid judgment. You might be able to get a waiver of rent or a better term so they can save money to move someplace else, or avoiding the eviction judgment really helps as well, because an eviction judgment can affect the ability to apply for and get other housing, or maybe even make people ineligible for certain housing subsidy programs, and affecting their credit in other ways. So again, just a general overview. You don't have to memorize everything from the training. We have staff attorneys that are going to help you and serve as mentors for you on your cases. We also have reference materials, and at the end we're going to show you the website and brief bank and resources that we're setting up. But we do want to give you a pretty detailed overview and training on eviction defense and on how this Shriver program is set up. One last point. Again, as we get into the technical defenses, we're not coming, the main point of what we're trying to do is what I mentioned, the access to justice and the fairness, leveling the playing field when one side is represented and the other side is not, and getting fair results in cases. We're not taking a position on broader political issues or landlord-tenant issues or whether rent should be paid in certain issues. Again, we'll advise you, but we'll advise you as you go through cases. The goal is we're representing clients, so it's really understanding what's in the best interest of the client that we're representing at the time. But because it's a volume project, and because we're all working together in this kind of exciting collaboration, we are also looking for issues that are broader issues that need to be addressed in the law. That where should appeals be filed? Where does the law need to be changed to promote fairness? So we will be talking to you about that as well. And so we'll jump right into the training. I'm going to introduce Javier Beltran. Oh, Cassandra is going first. Cassandra from Neighborhood Legal Services.
Good evening. My name is Cassandra Goodman, and I'm with Neighborhood Legal Services, one of the partners of the Shriver Housing Project. And I'm going to be talking a little bit about the Eviction Assistance Center, which is one part of the Shriver Housing Project. Before I get started on the specifics of what we do at the Eviction Assistance Center, I'm just going to kind of give you a glimpse of what a litigant should expect to go through once they are found to be eligible for our services. Litigants and tenants who come into the Eviction Assistance Center, as Amos already stated, would have to have an unlawful detainer filed against them at the Stanley Moss Courthouse in order to qualify for the Shriver Housing Project. In addition to having their cases filed at the Moss Courthouse, they would also have, the other side would have to have an attorney representing them in order for us to take the case, and they'd have to qualify under the income guidelines. If they are eligible, they would come to us. We would screen them to make sure that they are eligible, and then we would prepare documents for them and make a determination on whether they are limited or full scope litigants. And I will explain that in a moment. Limited scope representation. Well, the goal, as Amos explained earlier, is to level the playing field, make sure that tenants have the most assistance that they can get for their unlawful detainer, because there is a very serious thing that they could lose, which is their home. And so our goal is to try to help as much as possible. Now, we are supposed to serve about 5,000 litigants a year. So that cuts out a lot of litigants that we will not, unfortunately, be able to provide full scope representation or even limited scope representation to. And so our goal is to try to provide information, resources, preparation, as much as we can for those that are not going to be receiving full scope representation, so that they can at least have some idea of how to argue the case or handle their case at the Stanley Moss Courthouse. As you heard from Amos, fewer than 1% of unrepresented tenants win their cases, and there are a lot of reasons why that is the case. One is just the inability to communicate effectively. The other is they may have no defense to their case. The other is that they may have a lot of strong defenses to their case, but they lack the knowledge, the legal knowledge, to be able to argue effectively in front of a judge. I remember, being at I was there for another hearing, but I was watching a trial between an unrepresented litigant and a represented landlord. And the litigant came into the courthouse with his son. He was not served with papers that he was supposed to be served with for the unlawful detainer. And he actually had notarized form that said that he nor his girlfriend at the time were at home because they were working at the time the landlord allegedly said they were personally served with documents. And that's one of the requirements, as you'll learn later, for the landlord to be able to effectively evict a tenant. He has to show that he effectively served that tenant the unlawful detainer, the paperwork, or the 3-day notice, before he can go proceed with the unlawful detainer, because that's a defense to the case. And in this case, he had the documentation. He was able to effectively communicate this to the judge. It was clear to everyone that he did not get the paperwork, and he couldn't have gotten it, nor his girlfriend, because they were at work at the time. And they still lost the case. He still lost that case. So there's a lot of different reasons why tenants don't win, and we want to put them in the best position possible to be able to effectively represent themselves or represent them in their case and fight for them to be able to stay and maintain their housing. So at the Eviction Assistance Center, they come through and we make a determination or an evaluation of whether or not they should be limited scope or full scope. In a limited scope case, that litigant, once they come into the Eviction Assistance Center, will be assisted with the answer, the complaint or the answer to the complaint that was filed against them, and a court fee waiver. I don't know if you all are familiar with court fee waivers, but every time a litigant files an answer in response to a complaint, they have to, if most of our clients will be eligible for it, but they can file a court fee waiver to waive the almost $300 fee that they have to pay in order to file that answer with the court. And so we would assist them with preparing that paperwork, we would assist them with preparing the answer, and then we would provide them with detailed information about the UD or unlawful detainer process, what they should expect, and we would also give them counsel and advice on their specific case and what we think the merits of their case are, what points they should focus on when they go to court and are arguing their case before the judge. And we also have referrals for clinics with other attorneys in our program that will provide additional assistance beyond that one day they're at the EAC to provide them some additional resources and help and assistance. We also, one more thing, we also provide them with a referral list of attorneys that they can contact, nonprofit attorneys or attorneys in the area that would be able to provide them assistance, or if they have the income, they can pay for to give them representation, because limited scope litigants do not get full representation through the Shriver project. Then we have the full scope representation model, which is those litigants that come in and they are given the same assistance as a limited scope litigant, and they are provided with the answer, the court fee waiver assistance, but they are also given an attorney and they are referred to one of the 3 agencies, Inner City Law Center, Public Counsel, or Legal Aid Foundation of Los Angeles, to work the case up and provide full representation at trial for that litigant. And this is where the pro bono assistance is very much needed and necessary because of the volume that we expect to see at the Eviction Assistance Center and through the Shriver Project. It is really, really important that we have assistance from pro bono attorneys that would volunteer to be able to take up some of the cases and help with the volume and the load that we expect. So hopefully all of you will be able to take part in that. If you wanted to volunteer or are available to assist at the Eviction Assistance Center and you don't have the time, or it's not really something that you're looking to do, litigate the case, then you have the opportunity to volunteer at the Eviction Assistance Center and meet with clients, interview them, provide advice about settlement options, strategy, and trial preparation. In addition to preparing the pleadings, as I previously noted, and participate in evaluating the case to determine if it's one that should be referred for full scope representation, or if that litigant only needs limited scope representation and maybe a referral for additional services through one of the trial prep clinics that we offer. And there's also brief additional training involved if you want to volunteer either at the Eviction Assistance Center, and through our partners, you would get additional training for actually litigating the cases. So that's my piece on the Eviction Assistance Center, and I do hope that I see many of you as part of the Shriver Housing Project. Thank you so much. Javier.
Thank you, Cassandra. My name is Javier Beltran from Inner City Law Center, directing attorney. And I'm going to talk about a very dry aspect of this presentation, which is the applicable law. And I'm hoping to spruce it up as much as I can. But as dry as it may be, it is still the basis of any unlawful detainer in any case, even though it, in an unlawful detainer case, is a little bit less formal than a lot of your civil litigation cases. It still has many and mostly all the formalities of a regular civil litigation case. So let's start from the beginning and let's actually talk about what an unlawful detainer is and the meaning of that. And if you look in the California Civil Code Procedure 1161.1, it gives you a basic definition is when he or she continues in possession in person or by subtenant of the property or any part thereof after the expiration of the term. So basically it's somebody who is unlawfully in possession of their residence. Now, there's an assumption here that whoever your client is or the tenant is, there's an assumption or presumption by the legal system that they are in illegal possession. So you're already kind of working with one less wheel here in your car. So the fact that you kind of have to basically work in a very defensive manner here because the court system is already looking at you and saying, well, what's the reason for you being in your client being in unlawful possession of the property? And there could be several reasons. Expiration of the lease term, which will be some of the reasons as well. Default of the payment is usually what we'll see as well. Failure to perform covenants. So every lease has terms and conditions that each tenant has to comply with, and sometimes your tenant does not, and if they fail to perform based on your lease, then they could evict that person for that particular reason. There's also waste, nuisance, and unlawful purpose. So if somebody is selling drugs on their property, on their unit, within their unit, then that could be a reason for evicting them. And then if a tenant gives 30-day notice, obviously if a tenant is moving, then they have to give their landlord a 30-day notice. You won't see those situations because that's when a tenant voluntarily chooses to leave rather than having an unlawful detainer complaint filed against them. So these are the basic California laws that you're going to be focusing on when you do research or if you have questions regarding certain procedure or obligation. So the first one is California Civil Code 1940 to 1951.1, and that really lays out the landlord-tenant obligations that arise from a tenancy. So this is where you're going to look at, and especially if there's an issue of habitability and if there's conditions in the property that the landlord is not complying with. So there's basic rules and there's basic conditions that a landlord has to maintain a unit under. And if they do not, they're in breach of that statute, and then that could be serve as a defense. And you'll see this a lot in conditions where the landlord just fails to make repairs. And I've seen them because I've litigated many unlawful detainer cases and affirmative cases against slum landlords, and it's an issue of basically a bottom line or profit margin where if the least amount of repairs for the maximum amount of profit, this is what they're doing. So the least amount of repairs they're gonna do because a lot of folks who live in slum conditions actually do not make complaints, and so you'll see that a lot. And California Code of Civil Procedure, this is where you'll see a lot of proceedings, the laws regarding the procedure of an unlawful detainer case. So all unlawful detainers cases must start with at least a notice, a 3-day notice to pay or quit, or a 3-day notice to perform, or a notice to quit, in which Tamara will be talking about after me regarding with specific notices. But there is always a procedure to this in which you have to comply with the 3-day notice. If you don't, then it goes on to the complaint, and then it goes on to the court trial process. And so these are the rules that each landlord and each tenant has to comply with. And then there's also the California rules of court. Since all the cases that you guys will be handling will be from Stanley Mosque, it is the LA Superior Court courthouse, and so it also complies with the California rules of court. Now, the local rules, and the main local rule that you're going to really be focusing on is on the rent stabilization ordinance, or called rent control, and that's going to be within the city of LA. If you need to find that, it's in the Los Angeles Municipal Code, and easier, you'll find it online at amlegal.com. And in Los Angeles, click on California, click on Los Angeles, and it'll give you the entire municipal code. It's a really easy and accessible website in order to look at the rent stabilization ordinance. And also, since it is, like I said, it is Stanley Mosque that you guys will be seeing cases from, you can look also online to Los Angeles Superior Court for any local court rules that Stanley Mosque complies with. So let's look at the protections under rent control. One of the basic ones and one of the main stays of rent control is the rent increases are limited on a yearly basis. So you could have situations where a landlord could decide, you know what, decides a tenant is not paying enough rent, or they're not paying market rent. So they're paying $500 on a 1-bedroom that they've lived in there for 10 years. Market rate right now, perhaps $1,000, $1,100, $1,200. The landlord can just say, all right, let me increase it $500 for the upcoming year. Under rent control, there's only on a yearly basis, they can only increase it based on what the Los Angeles Housing Department determines is the increase. The bottom is 3%, then the cap is 8%, and they only increase it once a year. So right now, if I'm correct, it's 4%, right? So 4% is only the amount that they could increase rent. And they also have to give prior notice in order to increase that rent as well. So it comes up a lot in the fact that a lot of landlords don't know rent control applies to their property, and also in the fact that they want to increase rent to the rent control units as well, and they want to circumvent that. Now, for a lot of our tenants, it's a burdensome because it's a sudden increase, and it's an increase that they may not afford. And so for them, it becomes an issue because if they can't afford that rent, a lot of times they can't afford any subsequent rental unit afterwards if they happen to be evicted. Greater tenant protections. So, and we'll see a couple of the just cause reasons for evictions, but you just can't evict somebody for any particular reason in rent control. So in the city of LA, compare that to, say, Long Beach, which does not have rent control. I received a 60-day notice saying I have to leave because I was living there for 3 years and I was paying low rent, and I knew that, but my landlord wanted me out because she wanted to bring in new tenants to increase the rent to an unreasonable amount. So they gave me a 60-day notice and I left within 60 days. They can't do that in the city of LA because of rent control. And if they do, then that's an affirmative defense based on the rent control ordinance. And so there are certain reasons you can evict people for, and we'll talk about them in the subsequent slides, but there's only 12 enumerated reasons why you can evict somebody. Obviously, one of them, and we'll talk about this, is not payment of rent. If your tenant's not paying rent, then they could evict them for that particular reason. And then also, relocation assistance is available in certain situations and very limited eviction situations. So it's a possibility, but it is something that it basically is specific to a situation. So it's something that you should consider, and it's something you should look into a little bit more before, if there's a situation, for example, if a government entity wants to take over a property and they wanting to evict a tenant, then that's a reason for relocation. So what is subject to rent control? Properties within the city of Los Angeles. So they have to be situated within city limits. If they're not, then it doesn't fit under rent control. So it doesn't apply to the whole county, it's just particularly to the city. Property is built before October 1st, 1978. So anything built after that does not apply to rent control. And property has 2 or more dwellings on the premises. So single-family housing, which is just one unit, one house, and it has 3 to 4 bedrooms, and it's not rented out, that rent control does not apply to that particular unit and that particular property. All right, so these are the 6 common reasons for eviction. So these are the ones that we see the most in our practice in regards to getting reasons for evicting somebody from a rent control unit. So failure to pay rent. This is one of the more obvious ones, especially now in this hard economic times. People can't just pay rent, so a landlord can go forward and give a 3-day notice in order to move on in with an eviction proceeding. Also, obligation of a covenant, failure to perform a covenant in their lease is a violation, and if they don't conform with the breach, then the landlord could move forward on that. And one of the situations is when we see a lot of is, for example, a dog. So if somebody has the lease agreement specifically states you cannot have a dog, and if you do want to have a dog, you need permission from the landlord in order to have it. Tenant brings the dog in without the landlord's permission, has it for at least a couple weeks. Landlord notices, gives them a notice saying you need to get rid of the dog. Tenant doesn't get rid of the dog, they're in breach of the lease, and so if they don't, then the landlord can move forward and start a proceeding for an unlawful detainer eviction at that point. Committing a nuisance or causing damage. So this is a situation where we're having a tenant who's causing fights with other tenants, who's becoming making excessive noise and unreasonable times. So this is a situation where you see, given a history of this, that a landlord could move forward and evict a tenant based on nuisance. Also, refusing reasonable access. We see a lot of this mostly in a situation where the landlord and tenant don't have good relationships, where for some reason the tenant doesn't like the landlord or the landlord doesn't like the tenant. Then we'll see a situation where the tenant doesn't allow the tenant doesn't allow the landlord to have access to make repairs, to inspect, to basically do things that they need to do in order to repair the unit. And if that's the case, and if given the opportunity constantly to not to come into their units, then the landlord can proceed moving forward with an eviction based on not having access to the unit itself. But you have to give a notice. They have to give opportunity to comply, and then if the tenant doesn't comply, then we're in a situation where they could file an unlawful detainer complaint in order to evict the tenant. And then also, if the landlord does seek a situation where a relative or themselves want to occupy a unit, then they could do that as well. But they have to give the tenant notice as well in regards to moving in and in order to move into that particular unit. And then also, if the landlord seeking possession in compliance with a government order, so if there's a government order out there stating that the tenant has to leave, then the tenant has to comply with that as well. All right, so I'm going to start you off. So that's kind of ends the legal aspect of it. Again, there's binders, and then there's also going to be a resource library that you could look at in regards to finding the laws and regulations and rules for an unlawful detainer. But it's not as difficult as it may seem. It's actually, so you could barely find these laws here as you go. So let me start a little bit with the eviction process, and then Tamara from Legal Aid Foundation will continue on with that to just kind of give you kind of an overview before we get into the specifics. And so with any case, there has to be a notice posted or served upon the tenant. So the parameters of the case starts with a notice. It could be a 3-day notice to quit, which means you have to leave in 3 days because you did something, you did a nuisance, as we explained before, you did an illegal act, or in a situation for a 3-day notice to pay or quit, you didn't pay your rent, and you have 3 days to pay your rent. So the notice is always the start. And then from there, depending on whether you performed or quit, if you performed or you did not perform, then if you fail to perform according to the notice, then the eviction proceeding starts with the unlawful detainer complaint, which is the filing and service of the complaint, which has to be served again to the tenant as well. Tenant has the responsibility to respond and give an answer within 5 days If they do not, then at that point, there could be a default against the tenant, and then lose the opportunity to defend their case unless there's a specific reason why they didn't file an answer. And then after that, there are discovery, and then discovery during that process, there's subsequent trial, and then from there, there's a judgment or a settlement between the parties. And a lot of these cases do settle. I would say probably 85–90% of these cases do settle. There are situations where it is very adversarial, and we have no choice but to go to trial. And we do jury trials and we do bench trials. And so it's come in a situation where if you're looking for that kind of experience, then unlawful detainer law and unlawful detainer cases could be for you guys, because it is quick, and it's with a situation where I was in civil litigation before, and time frame to me seemed like this. I caught the big fish, right? And with unlawful detainers, I caught pretty much a perch or something, very small, right? So it is very quick, it's very fast. I like that personally, because the thing is, basically you're working at a quick pace. You get your resolution pretty quick. You don't have to wait 2 to 3 years. God forbid if it's a federal case, you're waiting beyond that. So here you're looking at a time frame of really maybe 30 days. And so just to kind of give you a background of how it looks for us, we received the intake file from the Eviction Assistance Center where Cassandra works at as of day one. That's what we're counting at this point. The firms will probably not receive that case on day one, because we were evaluating the case and figuring out whether we should send it over to pro bono or should we just keep it internally. From day 2 to 14 is when we do discovery, and that's automatically done per our cases. So we're sending out discovery. And opposing counsel does not like discovery, because that makes them work. And they don't like work. They're used to a system where they're having unrepresented clients do no discovery and basically can't defend their cases. This changes the balance of power here a little bit, because now they're hustling, now they're working. And so trust me, you guys are going to be significantly better than your competition on the other side. Significantly. So whatever discovery that we've given out or you're going to give out, it's going to pretty much overwhelm them. So especially for our cases, because we're having a lot of cases, we're handling a high volume of cases, so they are going to be overwhelmed. And so this is going to give you a great opportunity to get a pretty good result for your client. And this is the key here, because the client on the other side is really, if they don't get a good result, they might end up homeless in that situation. So this is what we're really fighting for here. So from there, you get the trial date notice. And the trial date notice is important because there's a lot of deadlines associated with the trial date. And then you have maybe 5 to 10 days to trial prep with your client. And then within that, you have trial. At that point, you could settle, or try to settle before that, or settle the day of trial, which we see a lot of as well in our situations. And then from there, any post-trial matters with your client, and that'll be that. Very fast, very quick, but we'll hopefully get good results out of this. So beyond that, Tamara from Legal Aid Foundation of Los Angeles will discuss the eviction process, and she will get you a little bit more specifics on what to look for in an unlawful detainer case, and if you get to file, what to look for as well. Thank you.
So good evening, everybody. My name is Tamara Kenyon-Dewey. I work for Legal Aid Foundation of Los Angeles, and I'm based out of the Long Beach office. So this is a very good tree of the unlawful detainer process. As Javier said, the cases start with some type of a notice, and most of the time you'll get a notice, because most of the cases will be rank controlled. You'll get a notice that's some type of a 3-day notice, unless you get a subsidized housing case, which you could see a 10-day notice or a 14-day notice, but mainly a 3-day notice. Then the unlawful detainer is filed. A summons and complaint is filed with the court. An answer is filed. Trial notice. You go to court. You settle. A lot of times you'll settle in the hallway. Don't be discouraged if you try to settle beforehand and you're not getting anywhere with opposing counsel. They get an appearance fee when they come to court, and usually they're very willing to settle on the day of trial. So keep pushing along on the day of trial to try to settle if that's what your client wants, especially if your client wants to move. If you're not able to settle in the hallway, and literally in the hallway outside of the department, you will have a trial, or unless you can convince the other side to dismiss the case if you have really good evidence, you will have a trial, either a jury trial if you have demanded the jury trial and paid the fees, or a bench trial in front of either our commissioner in Department 94 or one of the limited jurisdiction judges that are available for the case to be heard. Technical defenses versus habitability. Usually, well, I wouldn't say usually, but a lot of times you'll have a technical defense you'll be able to argue based upon the notice. If not, you want to look at some of the other affirmative defenses such as habit, waiver, estoppel, and there are a host of others that we will be more than happy to provide you advice on. If you lose at trial, if you win at trial, that's great for your client. Your client gets to stay in the property and pay their rent. Ultimately, that's what they're winning, the right to pay their rent going forward and whatever is outstanding during the trial process. If you lose your case at trial, then your client will have to move unless you decide to file an appeal or some sort of a post-judgment motion. And let me know if anybody has any questions. I'm more than happy to stop and answer any questions throughout the process. So step one, the notice. The notice is a very important part of the process because it starts the eviction process. And I like to say, the way I like to describe it is, it drives the UD. It's what the judge cares about. Did the tenant get the notice? What does the notice say? Does it comply with the law? Because it's a summary proceeding, the notice has to comply with the law. And the judges are pretty good at this. So if you have a 3-day notice that's missing the amount, or you have a 3-day notice that has the improper amount, that's a big deal because the tenant really only has 3 days to comply. And so you want to look at the notice, make sure it has all of the elements it's supposed to have. If it's missing something, that's an important part. I had a opposing counsel try to argue substantial compliance as a defense because his notice was missing some very key parts, key pieces. And the judge just said, no, you have to have what's required under the CCP. So make sure you look at the notice. Look at it twice. I always do. Counting the notice, day one starts the day after the tenant receives the notice, not the day the tenant receives the notice. Always ask your client, when did you get the notice? A lot of times it's very different than the date that's on the complaint. Three-day notices to pay rent or quit are the most common notices that we see, although landlords are becoming a lot more creative these days when it comes to rent control properties and are coming up with all kinds of reasons to try to evict tenants. So here's an example of a proper 3-day notice to pay rent or quit. At the top, it usually has the tenant's name, the tenant's address, and then it has the amount of the rent. Sometimes it has the monthly rent, but particularly the amount of rent that is due, and that's really the most important part. With a lot of the rent increases, sometimes landlords don't follow the rules properly with the LARSO rent increases. So if it's a 4%, they might raise it 5%. So check with your client. Always ask questions. Do you have copies of your receipts from the last 2 years? And the other thing about the rent increases is the fiscal year starts in July. And so if the landlord hasn't kept up with the proper rules and the changes, they might think that, you know, the percentage in May is the same for the percentage in August, and it may be different. So always ask questions of your client about what they've paid in the past. Has the landlord ever served a notice prior to the increase? All of these things are very important in determining whether or not the amount being demanded on the notice is the proper amount. If you look further down in the lease, the stuff in the center is all just sort of form language that you see on all lease agreement, on all 3-day notices to pay rent or quit. It tells them basically you have 3 days to pay or get out of the unit. And then that's when, if they fail to do one of those two things, that's when they sort of have unlawfully detained. They're in the apartment without permission. And then any legal action can result in a judgment. They're declaring a forfeiture of the lease. The portion toward the bottom, the 5 lines, the person to pay the rent to, the address where the person is available for the rent to be paid, the days of the week the person is available to accept the rent, the times in which the person is available at that location, and a phone number. Those are all requirements per CCP 1161 subdivision 2. It's all in there. If one of those things are missing, with the exception of a P.O. box being the address, then you have a defective notice. If you have an address and the landlord wants the tenant to pay in person, you have to have the times when somebody is available to accept the rent. You can't just expect the tenant to guess. Any questions about that?
So that's denied, they just go back and fix it and just start the process right away all over?
So the question is, if it's a technical defect, will they just dismiss it and fix it and go back? Yes, typically they do. A lot of the regular attorneys in the plaintiff's bar that do evictions, if you pointed out, hey, this is a problem, even with the rent, I've got proof your client improperly increased the rent, or your notice is missing X, Y, and Z. If your client wants to move, it's an opportunity for you to have a really good settlement. I like to use my defenses, my really good defenses, as a way to settle cases if my client doesn't want to stay. Or if your client wants to stay and maybe needed a little bit more time to collect the rent, maybe you can offer the rent instead of them having to redo it. The goal is always to try to prevent them from having to come back and be in the same position they're currently in going forward. But ultimately, yeah, most likely they'll just dismiss it and start over. But the landlord doesn't want to pay that extra attorney fee, and then there's a $300 filing fee for complaints as well. So if they can avoid that and you can find a way to make it to their benefit, they'll do that. Some of the important things to look for on the notice: they cannot demand rent beyond more than 1 year, which is also in the statute, and then it has to be registered under LARSO. So the city of LA collects money per unit, rental unit. That's considered a LARSO, or a rent-controlled unit. And if the landlord has not paid, he is not allowed to collect rent from the tenant. And there are ways that we can help you in determining whether or not it's rent control and whether or not they've paid the fees. Notices to perform, covenant, or quit. So these are notices that are given if a tenant has violated the lease agreement in some way and the tenant is able to cure that violation. So Javier mentioned earlier about a tenant having a dog and he wasn't supposed to have a dog. The lease clearly states you're not allowed to have a dog, then you're not allowed to have a dog. If the landlord serves you a 3-day notice, the landlord must state you have a dog. You need to get rid of the dog within 3 days. You're in violation of clause 2 of your lease agreement. Please get rid of the dog. If your client fails to do so, then the unlawful detainer can be filed. There are a whole host of defenses that can be used in cases like these. You have waiver, you have estoppel. Sometimes there's a reasonable accommodation if there is a disability and it's a service animal or a comfort animal. So there are all different ways that we can, tools that we can use to fight these types of cases. But essentially, it's a curable breach of the lease agreement, and the landlord has to give the tenant an opportunity to cure. RSO provides more protections or requires more information than the statute does. The statute under CCP 1161 subdivision 3 just states that you have to provide the information, but RSO says you have to give the time someone witnessed the breach, the date the person witnessed the breach, who witnessed the breach, the circumstances of the breach, to put the defendant on notice of what they have to do to actually cure the breach within the 3 days. And again, that's because of the summary nature of these proceedings. And then you have to have a lease agreement. You can't have a violation of a lease if there's not a lease. And these come up a lot more than you might think. Notices to quit are 3-day quit notice, meaning you have a breach of not necessarily a lease, not always a lease, but there is a breach of the rental agreement in some way, shape, or form, and it's not curable. So going back to the nuisance examples, loud noise over a consistent period of time, fighting, we get a lot of fighting cases, neighbors fighting neighbors, and one neighbor is being evicted for nuisance because effectively they are they're breaching other neighbors' quiet enjoyment, ability to use the property in a quiet manner. Those are incurable. Sometimes you will see a notice that has a curable breach, but it's on a 3-day notice. So those are defenses to these type of notices. And then also the same code section in the RSO applies to the 3-day cure or quit. You have to have the date, the time, the name of the witnesses, and the circumstances sufficient to put the tenant on notice of what they have to do to cure, of what actually happened in this case. So defenses to the notices, I've talked about some of them. Here they are listed. 3-day pay or quit. Sometimes the rent's not even due. If there's been some sort of a verbal modification of the lease agreement, maybe the rent is no longer due on the 1st of the month and the tenant has been paying consistently on the 10th of the month, that could be a good defense to a UD. Late fees are in the notice. There's some case law on late fees and issues that come up with late fees. So if you ever see late fees in the notice, you're going to want to talk to your mentor about that. Incorrect rent being demanded. Landlord has been collecting too much rent over the years. That comes up a lot with LARSO. It comes up a lot with subsidized housing. Always ask and make sure we do a lot of rent charts. We have a lot of examples of things of those that we can provide you. You fill in the blanks. Sometimes you pop up with a pretty nice figure that you can work with for your client. You can get maybe some of that back. You can get that rent applied, that overpayment applied to rent that's owed. There are many different things you can do with that. Failure to register, we talked about that. Fails to state with specificity pursuant to CCP 1161-2, and it wasn't served. It happens a lot that the tenant will first find out about the 3-day notice when they get the unlawful detainer. Talk to your client, find out if they were served, when they were served. If they were not served, make it an issue when you're defending them at their trial. Perform or quit, there's no written lease. They fail to state how they can cure the violation, or they fail to provide the sufficient information per LARSO. And then the quit notice, the big thing with that is that it's an actual curable breach, or maybe it doesn't rise to the level of nuisance, or maybe the tenant wasn't the aggressor in the fight between the neighbor and herself. She was actually defending herself, so she really didn't commit a violation. So we have a little bit of an exercise here. If you return to your this section of your PowerPoint, identifying a defective notice, just take a minute to look at this particular notice and see if you're able to identify any defects. Do we not have the big one? Can you see it? So there are 5 defects in this notice. Start with number 1, which is in the second paragraph. As of March 26, 2011, your March rent payment is 26 days past due. Your rent is due on March 25th, 2011. So in this particular instance, the notice was served or issued on March the 26th. So it's only 1 day late. So the language of that particular that particular paragraph in the notice is incorrect. It's only 1 day late, not 26. The second defect would be the late charges assessed in the breakdown of $50. The third one, in the second to the last paragraph, if payment is not received by March 26, 2011, legal action to enforce your obligation under the rental agreement may be taken. It does not give 3 days to pay the rent. It's supposed to say you have 3 days to pay this or quit. Also, defect number 4 is in that same sentence. It says legal action may be taken to enforce. It will say it has to be more affirmative. Legal action will be taken, and that's the declaration of the forfeiture of the lease that's required. And that can be found in the section, the CCP section 1161 through 1179 that discusses that particular part of the code. And then the fifth one, it's what's missing. There isn't anything showing where to pay, who to pay, what the times are. There is a phone number, but you have to have it very detailed for the tenant so that the tenant can pay on the third day. There's no issue about where they're going to go, when they need to be there, who they need to ask for when they get there. Yes. The question is, what was the issue with the late charges? And the answer, yes, that they're there. There's some little, I'll just add a little caveat to that. There's some little things about late charges that I'm not going to get into, but if you see a late fee in the notice, you want to ask your mentor if it's a valid late fee or not. Any questions about that? Okay, so service of the notice. The notice has to be served pursuant to CCP 1162. Usually needs to be served personally, but often the tenant is not at the premises at the time it's been served. So usually if they're not at the home, they need to be served at their place of business, or if there's nobody there as well, you can substitute serve on a suitable person over the age of 18. That's also an issue. If your client was substitute served, you're gonna want to ask the age of the person who was served. I've had a lot of cases where the person who was served was 17, was 16, 15, client's teenage child, teenage niece. They just take it, they give their name to the process server moves on. So ask those questions. If not, they do what we call a nail and mail. They post it on the door and then they pop another one in the mail. Rarely will your client get them both nailed and mailed. Usually it's just nailed to the door. They rarely get them in the mail. I don't know. Post office just happens to lose every 3-day notice. Tenants may raise, so that if you get an answer that says that your client wasn't served, ask for a copy of the proof of service if it's not attached to the complaint in your discovery. You want to see who served it. Was it a process server or was it the manager? Was it the owner? Was it somebody else? Because there is an exemption for process servers in that they don't have to appear at trial to testify. So you want to know who served it. The unlawful detainer. The unlawful detainer is the summons and complaint. That's what's filed with the court to initiate the proceedings for a lawful eviction. Tenants are supposed to be served personally with the unlawful detainer. I say supposed to be because normally those are nailed and mailed. when you get a case, if they come into our office and it's been nailed and mailed, or it hasn't been served properly, there's an opportunity to file a demur. But when you get them, you will already have the answer. So those opportunities have long since passed. But just to sort of educate you, if they're doing things properly, there will be a posting order. If they're not able to personally serve the tenant, there will be a posting order included somewhere in your packet, or you might see something like that come up. If they can't, they're supposed to go back to court, request a posting order, and then they're entitled, as long as they've done their due diligence trying to serve the tenant personally, they're able to then post it and mail it to your client. Also, the tenants always get a copy of notice of unlawful detainer from the court once a summons and complaint is filed, and which is good for our clients because sometimes that's the only way they know that there's been an unlawful detainer filed against them, because the landlord either delays in serving them or has decided to not serve them at all and try to get a default in a sneaky way. So simply put, it states the basis of the eviction. On page 2 of the unlawful detainer, it will show you what type of notice was served, when it was served, how they allege it was served personally, substitute service, nail and mail. It has all the basic information. It's a form. It's 3 pages. It gives you all the information in a tight little package. Sometimes attorneys will use their own pleadings. Most likely you'll see just the form pleading. So common defects to the complaint: the notice is not attached. The notices are supposed to be attached to the complaint. Sometimes the landlord will serve 2 notices, so it's not uncommon to see a 3-day pay or quit and a 3-day cure or quit, especially in a late fee type situation, because the late fee clause is a separate clause of the lease. If they're doing things the right way and they want to collect both the rent and the late fee, you will see a 3-day pay or quit for just the rent and a 3-day cure or quit for just the late fee. So if you have more than one notice, don't be too surprised. Also, you'll see on the actual form pleading which boxes are checked off, so you know what type of notices were served. A lease agreement has to be attached if it's a 3-day cure quit situation or a 3-day quit situation, not a 3-day pay or quit, unless it's an oral agreement. If your tenant was not the named defendant, then you'll also see a prejudgment claim of right to possession included. It's another form. If a tenant is residing in the property but was not named on the complaint, they have the right to petition the court to become part of the unlawful detainer process. It's just a filing of the form. You'll have a copy of the form. Once it's filed, they're part of the UD. They're added to the process, and then they're subject to anything that good that happens or bad that happens in the case. But that's what the form is if you see it. Sometimes there's an incorrect address named, which is really important because if the address is not proper on the unlawful detainer, the sheriff won't be able to lock out the proper address if it comes to that point. And then standing has become a really big issue lately with the economy and foreclosures. You probably won't get a lot of those cases, but I do encourage everybody who gets a case, run the address. Just verify and see who the owner is. Sometimes you'll be surprised that the plaintiff, the landlord, the opposing counsel doesn't know that their client really doesn't own the property, and they've listed the plaintiff's interest in the property. They've checked off the box that their interest in the property is as owner, and that's a clear win. Or you can use it as a way to settle the case on behalf of your client. And then the last thing is that the complaint was filed before the notice expired. That happens from time to time when you have holidays or weekends. People don't count properly, and then the complaint gets filed either the day the notice expires or the day before, and there just isn't enough time after the tenant was served before the complaint was filed. Filing a response, tenants have 5 days to file an answer. If they fail to file an answer, then a default judgment is entered against them. So you'll always get the complaint and the answer. You won't have that issue to deal with. what you'll have is the ability to file a first amended answer. You can do that as of right within the first 10 days after the answer is filed. If the 10 days comes and goes before you're able to meet with your client or properly assess the case, there is the opportunity to file a motion for leave to amend. They're very easy, very straightforward. We have plenty of examples. Judges pretty much, they grant them quite regularly. I had one even granted on the day of trial because it didn't prejudice the other side. So always evaluate the case once you get it. Make sure there aren't any answers that need to be included that have not been included in the answer that you receive. So defenses to unlawful detainer cases, these are some of the basic ones that we use. I wouldn't say basic, but these are some of the ones that we use on a regular basis. Habit is a big one. I always like the example that we use sometime in our trainings with the SRO housing where there was a faucet that was on with dripping hot water, and the humidity and the heat, and ultimately there were mushrooms growing on this client's wall. So it can get really bad. Rats, roaches, mold. Mold is a big one because landlords tend to just paint over it between tenants, and then at some point it starts to come out during the tenancy. Just really, really bad conditions. Garbage stacking up, bad plumbing, bad electricity. I could go on and on and on. And the pictures are just as horrifying. So that's a really big one. And it's one that you want to investigate thoroughly and to make sure it's something that you can't use at your trial, because if you're successful at it, there's a really big benefit that the client receives. Waiver, the landlord has accepted rent after the notice expired. Tenant attempted to pay the rent, landlord has just refused. Landlord and tenant made an agreement for the tenant to pay rent at a later time. Landlord is going back on that agreement. Perform or quit notices. The tenant actually complied with the notice. Again, waiver is an issue. Estoppel is also an issue. Retaliation can be an issue if the landlord is upset because the tenant has filed complaints against him or her with LAHD, Los Angeles Housing Department, Building and Safety, Code Enforcement. Those things all come up. And then discrimination. There are some issues of discrimination if a tenant, say, has a service animal, landlord refuses to grant an accommodation based upon their disability. They have the service animal because of the disability. All of these things sort of come up when you're evaluating an unlawful detainer case. Any questions?
Down. That's it.
Like that?
Yeah. And then when you're done,
Do I have to introduce myself? Do I have to introduce myself?
just say
To talk about. Wait, some people are still. It's just I was not happy about it because I feel like the only reason he brought in the girlfriend or whatever is because he was led to believe that if he didn't bring her, they wouldn't help him. And I just feel like, no, he sought help from you for housing. And that's our priority. And it's just like, oh, so they were like, oh, suspicious. Like, they were nice. They were really nice. But they were feeling like they weren't liking the fact that we were trying to split them up. And I was really nice about it. I said, look, it's just, because in the past we've had cases where two unrelated people have different interests, and ultimately you guys may have the same goals, but just to avoid any potential interest. And they said, well, what if we just go, well, we don't want to be split up. What if we want the same attorney? Can we just go hire someone? And I just said, well, I could give you a referral sheet, and you could try to go do that tomorrow. So I gave them Eden and Boston because they just didn't, and I don't. Why are we? I work at public counsel, and I'm a staff attorney there. So I'm gonna discuss some of the pretrial issues that come up and some of the trial issues that come up. And then again, if you have any questions, just feel free to interrupt me at any time. So the way that a trial date gets set in UD matters is that the plaintiff usually requests a trial date. So the court will not set a trial date until it is requested by one of the parties, usually the plaintiff. And I think now in downtown, the policy is only if the plaintiff requests it, the trial date. If you see that there might be a potential conflict, or if you know that you won't be available certain dates, then it's strongly suggested that you file a counter request to set the case for trial, and where you indicate your unavailability. If you are considering going forward with a jury trial, even if you're not sure, but you want to reserve your client's right to a jury trial, then you request a jury trial. You could do it at any point in the proceeding, but definitely no later than 10 days from the date the notice of trial date gets served. You should also file an additional fee waiver. It is very likely that the defendant already qualified for a fee waiver. So at that point, you're filing an additional fee waiver asking that jury fees also get waived. If they did not qualify for a fee waiver, or if you are concerned that the additional fee waiver won't get granted in time, then it's suggested that your client file deposit $150. This is the jury fee required to reserve their right to a jury trial. And then before trial, you might consider a summary judgment motion. My opinion is they're a lot of work, and there's always a risk that the court will find that there is a disputed issue of fact. But if after doing discovery, you feel that the material facts are undisputed and that there's a strong likelihood of the motion getting granted, then that's an option. It's the requirements are similar to the requirements in a regular civil case, except that the notice period is different. It's 5 days. So if you personally serve a motion for summary judgment, you only are required to give a 5-day notice.
I have a question.
Yes.
Is the proceedings, are they recorded, or do you have to have a court reporter? Particularly if it's such a serious case that you're contemplating a jury, and I know that there is some issues with regard to the Central District and the other courts getting rid of court reporters. What's the situation with
a
UDs?
court reporter is not provided. If you want to have a court reporter, then you have to make arrangements before trial. I actually have been litigating. I'm sure I've been litigating for 5 years, and I have never had a court reporter in any of my proceedings. I know that some of my colleagues have had court reporters, and they've made those arrangements beforehand. So that is possible, but you have to make those arrangements beforehand. So you could always ask your UD mentor to help you with that process. And the thing with not having a court reporter is that it does become a problem. Let's say if we have to appeal, where now we're faced with a situation where we have to file a settled statement, and you are describing the proceedings, and then a judge says that's not what happened. So that is a problem. But of course, you never really know whether you're going to end up in an appeal until after the case is over. So with discovery, the Discovery Act that applies to other civil matters also applies to eviction cases. So you have the option of using any of the methods authorized by the Discovery Act, and that would be form or special interrogatories, admissions, requests for production, and depositions. It's the same statutes that apply, but they differ in the notice period for motions. Again, it's 5 days if you personally serve, and the time in which to respond. If you personally serve, it's 5 days. And if you express mail, the time to respond is extended by 2 court days. If you first class mail is extended by five additional days. So all the other court rules apply as they do in other civil matters. So if you're filing a motion to compel further answers, you're required to meet and confer beforehand. And what is also different is that discovery must be completed no later than 5 days before the trial date. And because of the summary nature, it's strongly suggested that you serve discovery as soon as you serve the answer, because otherwise you'll get a trial date a week and a half, 2 weeks later, and you've missed the discovery cutoff. Essentially, your discovery request would be untimely. So with pretrial preparation, you interview your clients, your witnesses, and if you're dealing with a novel or complex issue, that it's suggested that you prepare a trial brief. But also, if you're not dealing with a novel or complex issue, but you're dealing with a new judge, which has been happening a lot. There is a panel of 5 judges you could be sent to, and they seem to be rotating every year. So you may be in front of a judge that just came from family law or criminal law that is completely unfamiliar with UD law, and you're then in the position where you have to educate that judge via a trial brief. Pre-trial, you should evaluate the case to see what your client's goals are and whether settlement is possible. So you should try to reach out to opposing counsel and make a settlement offer. As Tamara mentioned earlier, don't be surprised if they're unresponsive. Some of them wait until the day of trial, and some don't. Some will engage you in settlement discussions. And also, you may get a not so favorable settlement offer initially, but you may decide, I'm just going to wait until day of trial and see if I could get a more favorable settlement, which can happen. If you feel that the settlement offer you're getting is not good for your client, don't feel pressure to suggest that your client accepts it if they have defenses. Defenses could be used as leverage. So that's a situation where you might decide, well, I have defenses. I'm not getting a good offer now. I'm just going to wait until the day of trial. With negotiation, you're usually focusing on a couple of things. So one is, can my client stay if that's what my client wants to do? And if my client can't stay, then what would be the terms of that stay? Sometimes opposing counsel will say your client could stay, they just have to pay the rent and our attorney's fees and costs. So we always try to get a pay and stay without the attorney's fees and costs. Sometimes we succeed, sometimes we don't. A lot of times it depends on how strong your defenses are and what the case is about. And in some situations where I'm getting offered a pay and stay with attorney's fees and costs, again, I might decide I'm just going to wait until day of trial. Maybe I'll wear them down. And I've succeeded in a lot of these type of cases. A lot of times the client says, I don't want to live there anymore. Even if you're telling them they have strong defenses, they say, I'm not getting along with my landlord. I don't want to live somewhere where there's just bad blood between me and my landlord. So I don't want to stay. I just want maybe time to move. I just want them to waive the rent, to seal the record. So that might be an option. If you are settling for a move out, the way that you may structure the stipulation is that you might offer, we could enter judgment for possession now for the landlord, but no money judgment, that's being waived, and we're sealing the record. That's actually a common way of structuring a stipulation. Or you may say, we're not going to enter judgment, we're going to just only enter judgment if there's a default. So if the tenant says they're going to move end of May, for example, then we'll set a compliance hearing for the first week of June. And if the client has moved out, then the case gets dismissed. If not, then judgment is entered for possession. And then we always ask that the record be sealed, and this is to prevent the tenant from getting an eviction on their record. There are companies out there that compile databases. What they do is they employ people to physically go down to the courthouse and look at these files, and then they acquire that information and put it in their database. So when tenants go and rent an apartment, their information is run through the credit check companies, TransUnion, but also through these eviction databases, which may be separate from the credit companies. So that's what we're trying to avoid. We're trying to prevent them from being essentially blacklisted and being put on these lists. A trial procedure. So UD court process is a lot less formal than in a regular civil courtroom. The cases all get assigned to Department 94. So on a regular day, there may be 30 to 40 eviction cases on their docket. So there's no check-in. The attorneys go in and they sit down, and then around 9 o'clock, the commissioner starts calling roll. So they start calling roll, and the parties stand up to let the court know they're there, and the attorneys stand up as well. Once the court is done with calling roll, then the parties go outside with their attorneys and start negotiating. So they're asked to go negotiate upstairs on the 9th floor, which is the cafeteria. So when you go into the cafeteria every morning, you're going to see most of the tables are filled with the attorneys and parties in UD matters trying to work out a settlement. If the case gets settled, then you take the agreement to the court clerk. And if the case can't get settled, then you inform the court clerk that you can't settle the case and you need to be sent out. And you give an estimated time. So if it's a bench trial, then you would give an estimated time. Maybe it's a couple of minutes, a couple of hours. If it's a jury trial, then it might be 2 or 3 days. Usually the estimate given for jury trials is 2 or 3 days. Also, the commissioner in Department 94 asked that the parties exchange exhibits, so that facilitates settlement. If you're able to see incriminating evidence against your client, or the landlord's able to see evidence that will hurt their case, and that might encourage settlement. If you are planning to proceed with a jury trial, then you need to go to court prepared, meaning that you have to have all your necessary documents, which I'll go over right now. Key players in the courtroom. So there's the deputy. There's one deputy assigned to Department 94, the judge's clerk. And I mentioned that if you settle, you give that person the stipulation, or if not, you let her know that you need to be sent out. And the reason I say you need to be sent out is because Department 94 usually only hears cases that will be less than 20 minutes. So they take the approach that if both litigants are represented, it's most likely not going to happen in less than 20 minutes. So they send the cases out to a different department. And this is a setup of Department 94. So the purple area are where all the parties sit, and then the attorneys go in and sit in these blue crosses, which indicate seats. Okay, so the trial process. Again, as I mentioned, you may settle for a pay and stay and a waiver of the rent, no waiver of the rent, a partial waiver of the rent. It just depends. And again, asking that the record remains sealed. And depending on the way you structure the settlement, maybe asking for a compliance date. If no settlement, you let the clerk know you can't settle, and you will be sent out to a different department. And that department would be Department 77. So with a bench trial, usually the judge prefers that you not give opening statements. It just depends on the judge. And then, it's like a regular civil matter, so the plaintiff presents their case first. There's opportunity for direct and cross of witnesses and closing arguments. When you get sent to Department 77, what that judge is determining is whether you're ready. If you, as the party that requested a jury trial, for example, do not have all of these required documents, then you may get sanctioned. So it's really important that you show up ready. Because you don't know what judge you'll be assigned to, you can't file your documents beforehand. So what you do is you just come to court with your documents, and once you get assigned to a judge, then you let that judge's clerk know that you have your documents, and you file it with that clerk. Yes. The statement of the case. So this is for a jury trial. Statement of the case, proposed jury instructions, proposed verdict form, witness list, exhibit list. Sometimes plaintiff maybe thinks that you weren't really going to proceed with a trial, so they don't show up ready, and may ask for a continuance at that point, and they may be sanctioned. If you are planning to proceed with a bench trial, then you don't need these documents, except, as I mentioned earlier, if you are concerned about dealing with a complex issue or a novel issue, or maybe you're concerned that you may end up with in front of a new judge, then you would have your trial brief ready. But the other documents would not be necessary for a bench trial. Hold on. Excuse me? No, because the plaintiff will ask for a continuance, and there's a strong likelihood that it gets continued, and they'll just impose some sanction, or sometimes they won't even do that. Okay, I think there's a slide missing. Okay, sorry, I skipped over this one. Okay, so I mentioned that you may proceed with a bench trial or a jury trial, and it just depends. So a lot of times we'll reserve our right to a jury trial, and then we don't know what judge we're going to get assigned to. So we wait until we get assigned to a judge, and depending on who that judge is and what we know about them and how they rule on certain issues, we may decide we want to waive our jury trial and just have a bench trial in front of that judge. But because a lot of our cases deal with credibility, in our experience, we have found that juries tend to find tenants more credible. And there are certain defenses that do better in front of a jury. So one example is you've heard mention of the dog case. So let's say a tenant's lived there for a long time, they're under rent control, they're below market, and their lease says no dogs. But they're not really sure what their lease says because it wasn't fine print and they signed it years ago and they don't have a copy. But they notice that the new tenants coming in are all bringing in dogs, and they're all allowed to have dogs. And so the tenant thinks, well, you know, I want a dog too, like everyone else coming in. So the tenant gets a dog, and now they're being evicted. And even after the 3-day notice, the tenant doesn't get rid of the dog because now they're really in love with their dog. And they figure, but all the other neighbors, the new tenants coming in, have a dog, so why can't I? So we might then proceed on a trivial breach defense. So where we argue, yes, the lease states that no dogs are allowed, but when you look at all these other factors, it amounts to a trivial breach because the landlord's not being harmed. The tenant maybe offered to pay a security deposit for the pet, and the new tenants are allowed to bring in dogs. So what's the big deal? And the jury sees it that way a lot of times. Yeah, what's the big deal? Why are we here on a 3-day jury trial? It just makes no sense. Or even cases where you may have what you think is a clear-cut defense, like a non-payment of rent, where the tenant is claiming, well, I have all these bad conditions, I asked for repairs, and I just got fed up when the landlord wouldn't make repairs, so I just withheld rent. You may look at pictures and see that there are really bad conditions and maybe have government reports, but the landlord could defeat your defense if they are able to convince a trier of fact that the tenant didn't let them in to make repairs. The tenant created a situation that caused those bad conditions. So now you have credibility issues. Or let's say on a non-payment of rent, the tenant doesn't notice that they always mail the rent a week before the rent is due because they're good tenants. And they don't notice that they accidentally were a digit off in the address. So when the landlord gives a 3-day notice, they don't understand why, because they already sent their rent and they let the landlord know, I sent my rent, and the landlord says, okay, I gave you a 3-day, but I'll give you a week to figure out what's gonna happen. So during that week, but after the 3 days, the tenant, the rent gets returned to the tenant. The tenant discovers, oh my God, I was a digit off, the rent never got there. But the landlord proceeds on the eviction, saying, but you didn't pay me within the 3 days. And the tenant says, but I tried to pay you within the week like you said I could. So now you have estoppel issues and its credibility. So that case would do better in front of a jury, because a jury would be more sympathetic, where they would say, like, come on, it was a few days off and it was clearly an accident. Whereas maybe a judge might say, but the law's the law. The law says 3 days, and I don't really believe you. But so those are some cases where you might consider, well, I do better with a LA jury pool, which tends to be more tenant friendly. Or will I do better with this judge? And sometimes we might even just ask ourselves, hey, I'm in front of this judge the morning of via emails. Should I waive a jury? What should I do? So definitely it's something that you should discuss with your UD attorney mentor. And then just to add to that, we've actually had cases where during pretrial discussions, the judge says, you're going to lose, your client's going to lose. And then the jury finds differently, right? So now we know, oh, in front of this judge, we're more likely to lose. Now we know, because you strongly stated that during pretrial discussions, and the jury didn't agree with you. So now we know. So, okay, post-trial then, once you have your stipulation in place and you're making sure that your client complies, if the case needs to be dismissed, you're making sure that that happens. If you win, if you go to trial and you win, then you have to make sure that now your client pays all the rent because the tenancy is reinstated. And if you lose, then you have to inform your client that the sheriff will execute a lockout 1 or 2 weeks after the trial. And then if there are some issues, you may consider filing post-judgment motions or maybe if it's something that should be appealed, the viability of an appeal. So post-judgment, same types of motions apply here: motion for a new trial, motion to enter new and different judgment. But there's a different type of motion here, in which it's called a motion for relief from forfeiture, where you could ask the court to reinstate your client's tenancy in spite of a loss because of some hardship. So maybe there's some issues of the tenant being elderly, having lived there for a long time. The breach was not a big breach. It was maybe caused because of a mistake. So the judge will weigh out the equities and might reinstate the tenancy upon your client's performance of certain conditions. So here in a UD, you have 30 days to appeal, and it's suggested that you file a motion for a stay pending appeal if you choose to appeal, because if you appeal and there's no stay, your client's not in possession. So even if they win their appeal, they're not going to be able to go back into their home a year or a year and a half later. The appeal continues even if your motion for stay pending appeal gets denied. Or if there are issues in which a writ would apply, then that's another option, filing a writ. Okay. Any questions? No? And now you will hear from Michael Soloff, and he's a partner at Munger, and he's going to talk to you about the pro bono partnership.
Thank you, Claudia. Good evening, everybody. As you've heard tonight, the Shriver Housing Project Los Angeles represents a truly extraordinary partnership between 4 of the preeminent legal services providers in Los Angeles County. And I think that Inner City Law Center, Legal Aid Foundation of Los Angeles, Neighborhood Legal Services, and Public Counsel deserve a great deal of credit for coming together to try and begin to address at least, the gross denial of equal access to justice that's occurring to thousands upon thousands of low-income litigants every year in Los Angeles. I just want to take a few minutes to remark upon the importance of extending that partnership from these agencies to the private bar. And I think I have some particular insight on that because I've done personally over 100 cases for low-income tenants in the UD or other eviction-related litigation over the last 6 years. First, by extending the Shriver Housing Project to the private bar, that many more low-income tenants will be given equal access to justice in what is a fundamentally important type of litigation. At my firm, we often refer to our biggest and most important matters as bet the company litigation. And let me tell you this from my personal experience. For the clients you will be representing in this project, this is bet the company litigation. And the reasons for that are simple. Security in somebody's home is one of the most fundamental things to all of us. And for low-income tenants, the consequences of eviction are generally far more than the simple hassle of having to move to a new location. Rather, eviction often leads directly to homelessness. And that's because they don't have the resources with which to go to a new apartment, come up with first and last month's rent, pay the cost of moving, and they also may be blacklisted if the fact that they were evicted becomes public knowledge through a credit rating agency, because many landlords won't rent to people who were previously evicted. Your representation will be able to avoid these dire consequences in most cases. Obviously, if you win or if you're able to negotiate a pay and stay, your client's housing is preserved. But even if you can't achieve that result, in many, many cases, you will be able to negotiate for your client enough time for them to find replacement housing and enough time when they're not paying rent at their old place that they can accumulate the resources that they need to move to a new location. And in virtually every case, you'll be able to get the records sealed so that the credit agencies will not report to the landlords in the future that there was an eviction and thereby protect your client's future ability to rent. While most of the cases obviously involve low-income tenants facing represented landlords, the project does have a number of cases already where there are low-income landlords who are facing represented tenants. I'm handling one such case right now, and I can tell you that in those cases as well, the consequences for the low-income landlord are extremely dire if they don't have legal representation when they're trying to deal with a lawyer on the other side. And this project is going to assure equal access to justice for all low-income litigants. One of the things that I think is somewhat extraordinary about this project is that you can have this very significant impact on your clients' lives for a relatively small expenditure of your time. Obviously it's very difficult to know exactly how many hours any particular case is going to take, but it's probably true that most cases will take you 50 hours or less, although there will occasionally be some that take more than that. And in that time, you're going to be able to really change the lives of your client. And I can also assure you from personal experience that you will find the manuals that are going to be made available to you, and you will find that dealing with the fine professionals at these great organizations will be extremely supportive, and that will really help you get through the process with flying colors. Finally, I just wanted to note that as important as the individual representations are, there's another, perhaps even more fundamental reason why it's important that the private bar participate in the Shriver Housing Project. As you know, this is a pilot project that's being funded for 3 years pursuant to state legislation that Mike Fuhrer carried through the legislature. There are social scientists who are going to track the cost effectiveness of what's done in this project. And at the end of the project, there's going to be a fundamental public policy choice for us in California. Is this the type of project that deserves our tax dollars, or at least court fees, to support going on past 3 years, and hopefully, if the resources are there, expanding? By participating in the project, you and the rest of the private bar will help leverage the resources that are already being put into this project, and thereby increase the cost effectiveness of the program, hopefully, therefore, making it seem even more worthy of continuing past the 3-year sunset. And of course, by participating in the project, you and your firms and the rest of the private bar will have a more persuasive voice in the public policy debate that's coming, based on your personal experience of what it means to see that low-income litigants in eviction cases actually have a lawyer when they're facing a lawyer on the other side. So the fact, obviously, that you're here tonight means that you get it already. I hope that you find your experience with the project extremely rewarding, as I found my work in this area over the years. And I would ask you to encourage others at your firm and others that you know throughout the private bar to join the Shriver Corps and support this wonderful project. Thank you.
Hello, everybody. My name is Tila Chalmers, and I'm the coordinator of this project between all the and among all the different legal services agencies. And I just want to really quickly, because I know we're short on time, I want to really quickly show you, because Javier is going to come over here and help me do this, right? Escape, maybe? Okay, show you that in addition to promising you that we will give you a mentor and that we will be there for you to answer any questions, there is also an online resource which is there for you 24/7. We're very dedicated, but we'd prefer not to take calls at 2 in the morning. But 2 in the morning is when you can go to this website. And we are going to take the sign-in sheet from this training and sign you all up for it. So first you'll see the URL is ShriverHousingLA.org. And you'll be getting an email from us telling you this. But you'll see that there are some things that are below the password or before the password. So you can read a little bit about the project. I have a Mac now, so it's having to get used to, okay. You can read a little bit about the project. You can see the different organizations here on the side and all of your law firms down there. You can look at our training calendar. At the moment, the only training listed here is today's, but you'll see that as we have more trainings, you'll find more listed. Project news will include articles about the project and so forth. But to get to the library, which is the main thing I want to show you today, you're going to need to log in. So to do that, you type in, and we will be giving you this, and then you can change your password so it's something that you remember. And that brings you to the library. This is what it has so far. We're still adding a lot of things to it. But for example, you will find here, under training manuals and legal resources, you will be able to locate the text of LARSO if you need it. You will be able to locate this manual, which Kristen will be doling out to those of you in Manat. They will be in your libraries, but you can get to everything here online. The municipal code, the California Tenants Guide, all kinds of resources are here. And then, under sample pleadings, you'll be able to get to pleadings that you can download that are in Word form so that you can use them as templates. So for example, you're going to trial and you need a trial brief on the subject of this is an illegal unit, there's one for you right there. You're going to trial and you need jury instructions in a habitability case, you would download them right here. So we're going to keep adding things to it. As you produce documents, we'll be able to add your documents to it so that we won't have to reinvent the wheel. You can get resources right here. We're also, though we don't have it now, going to be uploading video trainings, including this one here, and you'll be able to watch them as well as subsequent trainings that we'll put on special topics. So we're very, very excited to work with all of you. This is, as many people have said, a really groundbreaking project, and we're thrilled that you're joining us in it. We're happy to answer questions, and thanks for being here.
I'll see you.
See ya. Where do you live?
What's that?
Where do you live?
Sherman Oaks.
Okay.
But not really that far. Well, it's not even that. It's,
far?
well, not for me. Because like if you take Sepulveda,
Oh.
have you ever been up? You take
You
Sepulveda.
take it all the way up.
And you take it up, and if you go through the tunnel at the top, past the
Oh yeah,
schools,
go ahead.
Yeah.
first right into that neighborhood. So it's not that far.
Oh,